want nobody, and I don't want nobody. You got that right. And I don't want nobody. I lost want nobody, and I don't want nobody. Girl, man, with me, you got that right. And I don't want nobody. I lost Arnold Schwarzenegger, but it better. And I don't want nobody. Girl, extra work, you got that right.
Okay, that is the international theme song of attorneys who do not want pro bono clients or to have courts force them into representing clients. It's called I Don't Want Nobody. Okay, here we are, Unit 3. This is the video lecture for Unit or Week 3. Again, the lecture is to supplement your reading material and take you through the rules and maybe point out some rules that will help you when we get to class in the application of those rules. Class time will be spent answering the discussion questions in the beginning of the chapter, answering the questions, multiple choice questions at the end of the chapter, also going through the cases that have been assigned. Sometimes they will be quick, sometimes the cases are a little bit longer, a little bit more in depth. But the whole purpose is to spend as much class time applying the rules instead of lecturing about them. You should be learning the rules through your reading as well as the supplementary lecture video. So let's move on here. And we'll start out with a repeat from prior, I think this is Unit 1, Week 1. Has to do with declining or terminating representation. And as you said, I don't want nobody. We'll get into pro bono as well as court-appointed attorneys and when you can decline representation when it comes to a court-appointed attorney. And as you can see, as we get forward and from your reading, that pro bono is an aspiration and it is not enforced, at least by most bar associations, and it's not meant to be enforced according to the ABA model rules, or at least comment 12. So here it is. Except as stated in paragraph C, a lawyer shall not represent a client, shall not represent a client, okay, or where representation has commenced, shall withdraw, okay. So that's strong wording there, that this is not a discretionary decision for the attorney when the following: if the representation will result violation of the rules of professional conduct or other law. Quite often conflict of interest comes into play here. Those are rules 1.7, 1.8, 1.9. I'm sure we will get to them sometime in the semester, I'm sure. The lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or the lawyer is discharged. Now we have a couple cases about lawyers being discharged. One of them is where the lawyer claims that the one case is where the client claims that the court wrongfully did not allow them to discharge the lawyer, and the court said, oh no, yeah, you can't just discharge a lawyer. You don't have the absolute right to discharge a lawyer during trial. And we'll get to that a little bit later. And then here we have a step stated as, except as stated in paragraph C. We'll get to that. A lawyer may withdraw. So this is after a lawyer has already accepted the client and is representing the client. So B is a lawyer may withdraw from representing a client if, and again, we went through all these. And this is not and. These factors are not and. These are or. The conjunctive, if any one of these factors is applicable. So, can be accomplished without material adverse effect. 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal and fraudulent. So, remember, what's key is that the fraudulent or criminal behavior involves the lawyer's services. Number 3, the client has used the lawyer's services to perpetuate or perpetrate a crime or fraud. Again, it's the use of the lawyer's services. Number 4, the client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. A case or two in your reading for Unit 3, Week 3 concerning this. Number 5, the client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. There's a case that deals with this as well, and generally this is about the client is not paying the attorney. Okay, and there's also a case where the client's not paying the attorney and the court won't allow them to withdraw. That's, I think, the Rosenberg v. Levin case. Number 6, the representation will result in an unreasonable financial burden on the lawyer and has been rendered unreasonably difficult by the client, or other good cause for withdrawal exists. Where's the 1, 2, 3, 4, 5? Oh, number 4, the lawyer considers repugnant or the lawyer has a fundamental disagreement. So 4 and 5 are at play in your reading here, but remember this rule, A is shall not represent or must withdraw their representation when those three, one of those 3 things are found, and B is they may withdraw if any of these 7 things are found. Now we go on to C. It says the lawyer must comply with applicable law requiring notice to or permission of a tribunal when terminating a representation. So you just can't abandon your client. You have to seek what the law is, what the regulations are when it comes to wanting to withdraw from representing a client, and you must give notice to the tribunal before which you are appearing. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. Okay, and this will get into Rule 6.2 when a tribunal forces you or tries to force you to represent a client through its inherent, inherent powers of the court. And as you read in your reading, the case that was involved in the issue of a court ordering an attorney to represent a client, they said that the statute, that the legislature didn't make the representation a requirement. It said that a court may request an attorney to represent a client, and they said therefore the legislature, the statute didn't give them the authority, but they said however the inherent power of the courts do. All right, D, upon termination of representation, a lawyer shall take steps to extent reasonably practicable to protect a client's interests, such as giving reasonable notice to the client. Remember, you just can't say I quit and walk away. Allow time for employment of other counsel. If they still need a legal representation in the matter, you certainly need to give them time for other counsel, and during that time they will continue to be your client. You should treat them as such. Surrendering papers and property to which the client is entitled, and that seems to me from the reading, although it doesn't say specifically in the comments or other sections of the reading, that these papers are also basically the file that you've created on behalf of the client and the client's claim or case, or other work that you've done for the client. So that has to do with their papers and properties. Now, not everything you've done in the case is the property, but if you think of surrendering papers as like the client file, generally you're in good stead then. And property to which the client is entitled, and refunding any advance payment of fee or expenses that has not been earned or incurred. Okay, so once you withdraw, you need to give money back. If you have it that you have not spent, that if they gave you, $10,000 for and a retainer fee for fees and expenses, and you've only spent $5,000 of that in your representation, you have to give that back to them. The lawyer may retain papers relating to the client to the extent permitted by other law. It seems like, and it based upon one of the multiple choice questions at the end of the chapter, that some states will allow an attorney to keep the file of the client as kind of a collateral, if you may, in order to force the client to pay them. But not every state allows you to do that, or jurisdiction allows you to do that, and 1.16 recognizes that by saying the lawyer may retain papers relating to the client to the extent permitted by other law. So you have to know, am I allowed to do that in this jurisdiction? If not, then you have to surrender those papers at the end of the representation, or when you withdraw. Comment 5, it says whether a client can discharge appointed counsel may depend on applicable law. Okay, this has to do with one of the questions that you, discussion questions at the beginning of your reading. A client seeking to do so should be given a full explanation of the consequences. Those consequences may include a decision by the appointing authority that appointment of successor counsel is unjustified, thus requiring self-representation by the client. Okay, so in Ruskin v. Rogers, the court said there's no absolute right to discharge an attorney during trial. Okay, so that's when there's a time when you don't have that absolute right. Comment 9 says even if the lawyer has been unfairly discharged by the client, a lawyer must take all reasonable steps to mitigate the consequences to the client. So you can't take revenge upon the client if they unfairly discharge you. The lawyer may retain papers as security for a fee only to the extent permitted by law. Again, there goes that comment. When can they retain papers that are part of the property of the client? And it says see Rule 1.15 for safekeeping of property. It really doesn't specifically go into the client file there, but those rules apply if you just make the assumption that the papers, the client's file, is their property. Okay, let's move on to Rule 118, duties to prospective client. Okay, this is the client-lawyer relationship, and normally it's the start of the client-lawyer relationship, but a prospective client does not necessarily mean a person that becomes a client. All right, a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. So if you go in and you say, I have an issue, I'm looking for representation. Well, that's easy to see that there is a prospective client there. Sometimes it's not as easy to see. All right, so even when no client-lawyer relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information, except as Rule 1.9, which is duties to former clients, would permit with respect to information of a former client. All right, so you have to treat the person, the prospective client, and the information that you have gathered from the prospective client during whatever meetings you had concerning the possibility of forming a client-lawyer relationship. You have to keep that confidential. You cannot use it, and except based upon other rules. A lawyer subject to paragraph B shall not represent a client with interests materially averse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that could be significantly harmful to that person in the matter, except as provided in paragraph D. Paragraph D has to do with permission and all that stuff, so read paragraph D. I didn't include it here. If a lawyer is disqualified from representation under this paragraph, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter except as provided in paragraph D. So again, paragraph D, read that on your own. All right, so these are the comments. And this is comment 2, and I split it up to make a point. So, comment 2, a person becomes a prospective client by consulting with the lawyer about the possibility of forming a client-lawyer relationship with respect to a matter. Okay, whether communications, including written, oral, or electronic communications, constitute a consultation depends on the circumstances. For example, a consultation is likely to have occurred, meaning that there is a consultation concerning whether a person becomes whether there's a consulting about the possibility of forming a client-lawyer relationship. Okay, so for example, the consultation is likely to have occurred if a lawyer, either in person or through the lawyer's advertising in any medium, specifically requests or invites the submission of information about a potential representation without clear and reasonably understandable warnings and cautionary statements that limit the lawyer's obligations, and a person provides information in response. I look at this part of comment 2 as if the lawyer in some way had solicited such information. Okay, so through its advertising, there are all kinds of advertisements for lawyers in the United States. Some lawyers advertise for very specific claims. One claim is for mesothelioma, which is a cancer that people got, that people are known to get from being exposed to a certain chemical. So it says if you have been exposed to a certain chemical, you may get mesothelioma, so call us. Okay, so that seems like they're soliciting a specific type of business there and want you to call them and provide them with certain information. So it seems to be that if a person responds to that, that is, that becomes a prospective client because they are soliciting people to respond in the possibility of forming a client-lawyer relationship. Now, here's in the second paragraph, or the bottom here, now I split this up because I wanted to make a point. It says, in contrast, a consultation does not occur, meaning a meeting with the possibility of forming a client-lawyer relationship does not occur if a person provides information to a lawyer in response to advertising that merely describes the lawyer's education, experience, areas of practice, and contact information, or provides legal information of general interest. Such a person communicates information unilaterally, meaning it's not really solicited, it's unsolicited, to a lawyer without any reasonable expectation that the lawyer is willing to discuss the possibility of forming a client-lawyer relationship and is thus not a prospective client. Moreover, a person who communicates with the lawyer for the purpose of disqualifying the lawyer is not a prospective client. So basically, that second paragraph, or the second half of comment 2, basically says, look, just because you are contacting any lawyer and telling them something about a case or a claim that you may have does not mean that you have that this results in a consultation about the possibility of forming a client-lawyer relationship. For example, you might go to a site where it says medical malpractice lawyer, and the medical malpractice lawyer might just talk about, as it said, the lawyer's education, the experience in the areas of practice in medical malpractice, give you contact information, or provide legal information of general interest. You go out to a lot of websites for law firms, there's certain general legal information that they provide you. It's actually a good place to start certain research in certain jurisdictions before going to Westlaw and things like that. Well, they're not really soliciting communication from prospective clients when it comes to just providing that general information. So even, if you look at a firm and say, well, this will be a good firm for me, but if really they only provide you information about the firm and they're not saying, hey, has this happened to you? Then we need to hear from you. All right? That will not be considered, that person's communication would be considered more or less unsolicited, and thus they would not be considered a prospective client. And then the last sentence, it says, moreover, a person who communicates with a lawyer for the purpose of disqualifying the lawyer is not a prospective client. So, for example, like the prime example I can see is in divorce cases where one spouse goes to a lawyer that she thinks that her husband's going to go to, or that the husband thinks his wife is going to go to, one or the other, and they start talking to them and enter into a consultation about the possibility of forming a client-lawyer relationship, and they do that just so the husband or the wife can't go to that attorney. I actually saw that on an episode of 2.5 Men, so that's why it comes to mind. So therefore, that doesn't count. Okay. All right. Let's move on here. Public service, Rule 6.1, voluntary pro bono publico service. It says every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire to render at least 50 hours of pro bono publico legal services per year. In fulfilling this responsibility, the lawyer should. Now, the first two are about indigent people. Okay, so A, provide a substantial majority of the hours of legal services without fee or expectation of fee to persons of limited means. Okay, or organizations, charitable, religious, civic, community, governmental, and educational organizations in matters that are designed primarily to address the needs of persons of limited needs. So I have outlined and italicized should aspire. You're not required to do this. At least that's what the ABA rules. You should do this. They say you have a duty to do this, so you should aspire to do this, but it doesn't say shall or that you must do it. A lot of attorneys are not very happy, and hence the song, I don't want nobody, I don't want nobody. You got that right. They don't want to do pro bono work, and they don't think they should be forced to do it because they feel as though, look, they entered a profession, and there's other professions out there that people need just as badly and maybe even worse than attorneys. For example, like a plumber. Everybody needs a plumber. So should a plumber be forced to do free work? Plumbers can be licensed. Plumbers can be part of unions. So they have, that union is a quasi-government, at least in my estimation, is a quasi-government type organization. In the case that you have to read, it goes through a lot of stuff about interesting talk about why this should be, why lawyers are different, because we are officers of the court, we stand between the public and the government and things like that. Look, as far as I'm concerned, I don't think anybody should be forced to do anything when it comes to their profession. I think it's a violation of the 13th Amendment. It's also a violation of the 5th Amendment when it comes to the federal government, or the 14th Amendment when it comes to state governments. However, courts have not agreed with that, by the way. However, as Christians, I think it's a good idea to voluntarily do pro bono work. Okay? Because when you're forced to do something, it's not charity. But if you do it based upon your own initiative, based on your own beliefs, and based upon your own motivations, then it is voluntary and truly is charitable. Okay, let's move on. Rule 6.1, now we go. So it says they want you to provide substantial majority of the hours here, or you should aspire to do that. And then you can provide any additional services through delivery of legal services at no fee or substantially reduced fee to individuals, groups, or organizations seeking to secure or protect civil rights, civil liberties, or public rights, or charitable, religious, civic, community, governmental, and educational organizations in matters in furtherance of their organizational purposes, where the payment of standard legal fees would significantly deplete the organization's economic resources or would be otherwise inappropriate. So, for example, suppose you want to do some legal work for a church. Well, so that would be a religious organization. But you have to ask yourself, at least under the voluntary pro bono publico service rule, Would these additional services, would they meet the requirements or the suggestion of the rule? It says, where payment of a standard legal fee would significantly deplete the organization's economic resources. Well, suppose you are going to provide some services to a church that is unbelievably rich and has lots and lots of money because it has lots and lots of parishioners or congregants and sells lots of books or whatever. Well, I don't think it would meet the requirements here. Okay, delivery of legal services at substantially reduced fee to persons of limited means. Again, there's limited means, so it's not necessary that you have to provide them pro bono here. But in addition to the free services, you provide services to people of limited means at a reduced price. And most of the time, that means people who think they are of limited means are your relatives. Your relatives always want to get free advice from you if you're an attorney. So they consider themselves persons of limited means, no matter how much money they have in their pocket. 3, participation in activities for improving the law, the legal system, or the legal profession. That could be developing continuing legal education courses. That could be becoming a member of the Bar Association, either local or national, different organizations, or things like that. In addition, a lawyer should voluntarily contribute financial support to organizations that provide legal services to persons of limited means. So not only should you give your time and your talent, but they're saying you should give your treasure as well. All right, comment 1. So every lawyer, regardless of professional prominence or professional workload, has a responsibility to provide legal services to those unable to pay. And personal involvement in the problems of the disadvantaged can be one of the most rewarding experiences in the life of a lawyer. It can be, or maybe not. The American Bar Association urges all lawyers to provide a minimum of 50 hours of pro bono services annually. Comment 3, persons eligible for legal services under paragraphs A1 and 2, meaning persons of limited means, are those who qualify for participation in programs funded by the Legal Services Corporation, and those whose incomes and financial resources are slightly above the guidelines utilized by such programs, but nevertheless cannot afford counsel. I think comment 3 is a pathetic comment, because ABA is basically saying, well, we get to define who a person of limited means is. And I think it's tyrannical in a sense. And of course, remember, the pro bono publico service is not required. However, persons of limited means, doesn't that depend upon, okay, what situation the person is in? There was a homeowners in a state in the United States who came under the anviled thumb of the Environmental Protection Agency, a federal agency that was fining them like $150,000 a day for some putative violation of some rule about interstate waterways. When the people who basically wanted to build a house on property that had a reoccurring puddle. I'm serious. It had a reoccurring puddle that formed when it rained. And the EPA said, oh, no, this is part of interstate waterways and part of the migratory bird pattern, blah, blah, blah. So you can't build there. And if you do build, we'll find you. That person's, they may be strongly middle class, upper middle class, or whatever. But when it comes to the claim that was brought against them, they're a person of very limited means because the government is killing them with fines. So I don't agree with comment 3. I don't think you should agree with comment 3. Sometimes people who do have means, their means become very limited and become persons of limited means because of the claims or the legal situation that they are in. Number 12, the responsibility set forth in this rule is not intended to be enforced through disciplinary process. So, if you want to do this, you should do it. I think as a Christian, we should want to do it, but you don't have to do it. Rule 6.2 accepting appointments from the judiciary. Again, there are a lot of attorneys out there. The international song concerning accepting appointments, again, is I don't want nobody, I don't want nobody. You got that right. So a lawyer shall not seek to avoid appointment by a tribunal, by a court, to represent a person except for good cause. Okay, so you got to have good cause to avoid being forced to represent someone when a court says that you have to. And good cause includes representing the client is likely to result in a violation of the rules of professional conduct or other law. A lot of times that's a conflict of interest, but it can also be you may not have the competence to represent the person. That may be good cause, and remember, you have to give competent representation. Such as representing the client is likely to result in an unreasonable financial burden on the lawyer. I think we saw that in one of the cases as part of your reading for Unit 3. If they appoint a person to you in a case, I think it was the, the tobacco case, yeah, the tobacco case, where basically it says, look, or actually I don't think they went into this, but it said, in tobacco cases, they're extremely expensive because the tobacco companies don't, they throw everything at you. And they're not going to back down, and they're not going to settle. They're going to take it to court, and they're going to have expert after experts, and they're going to just, bankrupt you. So if the result is an unreasonable financial burden on the lawyer, they can avoid the appointment. C, the client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. I think we have in discussion problem number 1 for the reading assignment has to do with a woman who, I don't know if it's accepting appointment of a Nazi under a First Amendment claim, and it was you can infer from the fact pattern that the woman is a Jew who had ancestors who left Europe because what Hitler was doing during the Holocaust, rounding up and murdering Jews. So, someone who was in the Nazi party, for someone like that, or for generally most any normal people, would find that a person representing that would be repugnant to them. All right, so let's go. 6.2, accepting appointments. Okay, a lawyer ordinarily is not obliged to accept a client whose character or cause the lawyer regards as repugnant. Now I have over here, what about Rule 8.4G? And this has to do with misconduct, and it has to do with discrimination concerning bias towards certain suspect classifications of people, race, ethnicity, sex, and then there's also the transgendered in there, or the or sexual orientation. Well, what if you want to decline to fight for gay marriage, or what if you want to decline to fight for the fact that someone wants to force the government to pay for their sex change operation, and you would find that repugnant? Would you be in conflict with 8.4G there? I don't know. I would think that in California, New York, and other bastions of leftism, they would say that's not a valid reason. You can't find someone based upon anything having to do with sexual orientation repugnant, or now transgenderism. All right, number 2, for good cause, a lawyer may seek to decline an appointment to represent a person who cannot afford to retain counsel or whose cause is unpopular. That goes back to the reasons in the rule. Good cause exists if the lawyer could not handle the matter competently. We talked about that. Or if undertaking the representation will result in an improper conflict of interest, so that goes against the rules of professional responsibility. Or, for example, when the client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. A lawyer may also seek to decline an appointment if acceptance would be unreasonably burdensome. We talked about that, money, or time even. If the person has no time to do the rest of their work, then it would be unreasonably burdensome. Number 3, an appointed lawyer has the same obligations to the client as a retained counsel. So you can't, if a court forces you into representing a client, you have to try as hard as possible to treat that client just as you would any other client that you voluntarily entered into a client-lawyer relationship with. All right, the last part of your reading assignment, at least in the book, had to do with meritorious claims and contentions. Basically, if as a lawyer, if you bring frivolous claims before a tribunal, you could be sanctioned, censured, fined. All kinds of things could happen to you. In your reading, Federal Rules of Civil Procedure, number 11, that you could be sanctioned by the court and then fined and have to pay court costs and things like that due to the frivolous nature of the lawsuit. But the rule itself states, a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. So the first part of that is, look, if there's no basis in law upon which you are bringing this claim or fact for doing so, then you can't bring the claim. It's a frivolous claim. Now, it does say it is not frivolous, which includes a good faith argument of an extension, modification, or reversal of existing law. Now, as you've gone through your legal education so far, you have done things called law center arguments, and law center arguments are you're asking the judge to either extend or modify, change, or reverse existing law. And as you saw in your con law class, you have seen where in the Bowers v. Hardwick sodomy case in 1986, Lawrence v. Texas in 2003, or was it 2004, basically they brought and asked the Supreme Court, hey, change this rule. It wasn't a frivolous case, and the court actually ended up doing it. So just because the law may not be on your side doesn't mean that the claim is frivolous if you have a good faith argument to change, extend, or modify the law. So comment 1, in determining the proper scope of advocacy, account must be taken of the law's ambiguities and potential for change. Now, just because you bring a lawsuit and you have misinterpreted the law or something like that, that doesn't mean that it's frivolous, okay? So account must be taken for the law's ambiguity. So you might have interpreted it one way, and courts may have interpreted another, and you could have been wrong about your interpretation, but that doesn't make it frivolous because, as they said, you have to take into account the law's ambiguities, and there are usually many of them, and potential for change as well, because you could come in and say, well, it's ambiguous. I know that all precedent is against me, but this is a better statement of the law, so we want to argue to change it. That wouldn't be considered frivolous. Comment 2, the filing of an action or defense or similar action taken for a client is not frivolous merely because the facts have not first been fully substantiated or because the lawyer expects to develop vital evidence only by discovery. What is required of lawyers, however, is that they inform themselves about the facts of their client's case and the applicable law and determine that they can make good faith arguments in support of their client's position. Okay, so basically those first two sentences say, look, if you, with a good faith, bring a claim into the tribunal, into court, and you think you'll be able to develop that, it doesn't have to be absolutely developed at the time that the claim is brought, and that you have a good faith belief that you will be able to develop it through fact, through discovery, through investigation. Okay, that is not a frivolous claim. However, now it goes on to say, such action is not frivolous even though the lawyer believes the client's position ultimately will not prevail. So still, even if the client doesn't necessarily believe in the case, if there's a good faith belief that there is evidence and things to support that, and that they could win, it's fine. I don't even think winning or losing has anything to do with it based on that sentence. But now it says the action is frivolous, however, if the lawyer is unable either to make a good faith argument on the merits of the action taken, or to support the action taken by a good faith argument for an extension, modification, or reversal of existing law. Okay, so if you go into it and you don't think that you can make these good faith arguments, or you eventually realize that you can't, then that becomes a frivolous claim. Okay, comment 3 says the lawyer's obligations under this rule are subordinate to federal or state constitutional law that entitles a defendant in a criminal matter to the assistance of counsel in presenting a claim or contention that otherwise would be prohibited by the rule. Now, okay, when it comes to criminal matters, constitutional issues, and things like that, the gloves are off when it comes to this, okay? All right. Now we get to the California rules, the unauthorized practice of law, and we go into the, the Farnham v. State, is that the right case? Farnham v. the State Bar? Yes, that's the California case for unit week 3, where the person had been suspended. The attorney had been suspended and held himself out as being able to practice law. So a member shall not aid any person or entity in the unauthorized practice of law. So what is the unauthorized practice of law? A member shall not practice law in a jurisdiction where to do so would be in violation of regulations of the profession in that jurisdiction. Okay, so in Farnham v. State Bar, the unauthorized practice of law includes the mere holding out by a layman or a suspended attorney that he is practicing or is entitled to practice law. So, if you're a person that's not licensed, or if your license has been suspended, even though you got all A's in law school and you had passed a bar exam at one time, but they suspended your license, they disbarred you, or whatever, if you hold yourself out as an attorney to someone, that's the unauthorized practice of law in California. California Business Professional Code, Section 6126, actually makes the unauthorized practice of law a crime, a misdemeanor, subject to fines and or prison time based upon how many times you do it. The first time it's a certain amount of time and or a certain amount of money. The second time it's more time and more money. Okay, California Rule 3110, failing to act competently. And this seems to be the rule that's at play in the Farnham v. the State Bar case when it concerns the actions of the attorney in that case, where he basically abandoned his clients or didn't do what his clients needed him to do. It says a member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. For purpose of this rule, competence in any legal service shall mean to apply the diligence, and that seems to be what was most missing in the Farnham v. State Bar case, that the guy didn't follow up on anything. He didn't do anything that he said he was going to do. It wasn't really just procrastinating. It was intentional laziness and intentional failure to perform. So that certainly is a lack of diligence, and because there was that lack of diligence, he did not perform legal services competently. Let's go B. For purposes of this rule, competence in any legal service shall mean to apply the diligence, learning and skill, so that's knowledge and your professional acumen, and mental, emotional, and physical ability reasonably necessary for the performance of such service. If a member does not have sufficient learning and skill when the legal service is undertaken, the member may nonetheless perform such services competently by 1. Associating with, or where appropriate, professionally consulting another lawyer reasonably believed to be competent, or 2. by acquiring sufficient learning and skill before performance is required. So basically what that's saying is, look, competence does not mean that going into it you don't have sufficient learning and skill. Competence can be that you acquire that during the representation. And that happens especially for most young lawyers, because if you had to have the learning and skill required before the representation, you'd never have any clients, because until you actually practice law and start developing the learning and the skill, how can you get the learning and the skill? All right, so that just makes sense. Okay, so that's it for week 3, unit 2, and we'll take you out with a little bit more of "And I Don't Want Nobody."
And I don't want nobody. I lost Schwarzenegger. And I don't want nobody. Extra effort. I was fast. I could pose. And I don't want nobody. All the big my spice. Schwarzenegger. And I don't want nobody. Extra effort. You got that right. And I don't want nobody. All the big